on hearing stream 7, day 1 of 1, dealing with energy and network utilities. And we're about to hear from Transpower. Just before we do, in relation to the last submitter, I know we've directed conferencing by yourself and Mr. Matthews and Mr. Wesney. I'm conscious that getting together on a previous topic has been difficult for some of the parties, and particularly on the biodiversity matter with eco rules, and that came up again today. So I just want to encourage people to try and get that conferencing undertaken as soon as possible. Otherwise, we'll have a sort of a knock-on effect towards the end. Certainly in relation to Mr. Wesney gave an indication this morning that the eco conferencing, he was confident that that could happen within the next week to 10 days in time for right reply on this topic. I would hope that the same could happen in relation to the upgrade issue. So, same applies to the telecommunication issues as well. Okay, now, Transpower, welcome Ms. Singh and welcome Mr. Cloud. Apologies for the delay. We're now running 45 minutes behind schedule, but I'm hopeful that we can deal with your submissions and those of Ms. Rostock, who's also online for Orion NZ, before we break for afternoon tea, and then we'll come back and hear the remaining submitters for the day.
Thank you, sir. I'm actually very grateful for the delay today. I had a few transport difficulties, but I'm here now, so it turned out very well on my behalf. I'll just do a really quick summary, and probably the first thing to note today in my evidence is attachment A, which is the most substantial part of my evidence, just recording so much agreement between myself and the Section 42A report authors. That includes there being no outstanding issues in relation to the energy subchapter, and there were very few outstanding issues recorded in my evidence. Having now read the summary statement that from the commencement of this hearing, I can also add to that list my agreement in relation to NUP1, NUP4 and NUR19. So that really leaves very few outstanding issues at all for me to address today. So hopefully we can be very quick. Probably the first matter I wish to address is the summary statement notes a willingness to engage around a national grid specific effects of policy. And I know you've heard from me in several other hearings before about the merits and my view, the efficiency and effectiveness of having a national grid effects of policy, so that the nuanced approach taken in the national policy statement for electricity transmission can be reflected in the district plan in one place rather than scattered throughout the many district-wide chapters. The summary statement indicates a willingness to engage on that, and I'd like to signal that I'd be very happy to do so as well. And that probably dovetails a little into some of the witness conferencing that you've directed and has been undertaken and is to be undertaken as well.
Ms. McLeod, thank you for that. We tested that matter again with Ms. Treadaway this morning, and she confirmed that she's certainly open to having that discussion. It was on the basis.
It's Transpower.
Yes, sorry. If nothing, I'm being consistently inaccurate of my reference to Ms. Treadaway. It is Ms. Robertson, of course, and Ms. Adams is here today because Ms. Robertson is unavailable, so she's been taking notes. So the understanding is that such conferencing would be about repackaging matters as opposed to adding any new matters. Is that your understanding too?
Yes, that's absolutely my understanding. You've heard evidence on a number of district-wide chapters from me, yes. And I know that you've heard before evidence in relation to the direction in the MPSET for seek to avoid and the way in which that needs to be treated, include alongside some of the ways in which you consider effects for the national grid. So that evidence is all before you, and
Yes,
It's just about perhaps taking that relief and seeing how it might fit in a single provision.
yes, we're very willing to grant that opportunity, but not at the expense of the other conferencing that needs to be undertaken. We would say that whilst it's more than a nice to have. I wouldn't want to underestimate or underdescribe what might come out of that. But I guess the fallback position, if it is that if it doesn't, if you can't agree on something, then you've covered the issues through a belts and braces approach on the other district-wide chapters.
Well, that's true, Sarah. And I'm also very happy to assist in making things efficient by perhaps picking up the pen and having a first go myself and communicating with the officers that way.
That's very, very wise. We will finish the hearings at the end of May. We're deliberating and writing draft decisions as we go, so that it's not left to the end. And we're obviously revisiting those as we go also, from a bottom-up approach. But certainly we will want to have something, say, before the end of April on this sort of national grid policy matter.
Thank you. That's certainly a workable time frame.
Okay, well, let's leave it that you'll take the initiative, pen to paper, and the involved Miss Treadaway after that. Okay, now.
Okay, so if I turn to specific provisions and the outstanding issues, there are two. The first relates to policy NU P3, and in my evidence at paragraph 34, I support, I recognise that the section 42A report was uncomfortable with the use of by enabling new technologies in that policy. And I gave some consideration to that and suggested that perhaps enabling was a little bit too proactive, perhaps, and have suggested that instead by providing for new technologies might be a better expression. Now, the summary statement disagrees and still has some discomfort about what that means. And this may fall in a little bit to the nice to have category, but district plans have a long life, or they may have a long life. And I have a view that by providing doesn't necessarily enable it. Just if you think about it in terms of future applications and future technologies, it gives that pathway where things have come up that we don't know about now, but are very useful because they're network utilities and they make a contribution to the community. That I think there is some utility to this in the network utilities chapter, but I do think it's probably a nice to have rather than something that's driven
Yes.
very firmly by a higher order planning instrument.
Sure. Ms. McLeod, Councillor Plummer asked a very good question this morning that I wasn't able to answer really, and that was, what's the difference between providing and enabling in your view?
I heard a similar question in a district plan hearing last week. I understand enabling to be something that would drive a permitted activity or drive something that is made to happen, whereas providing for is more of a pathway. And the way for the national grid, I understand the distinction is that policy 5 of the national policy statement talks about enabling operation, maintenance and minor upgrading, but recognising and providing for new development, so that there are two different pathways for those different types of activities. So I do think there's a distinction, and I think one pathway is more permissive than the other potentially. Okay,
and enabling is more permissive than providing. Is that what you're saying?
Yes.
Yes. Interesting enough, the National Policy Statement on Urban Development has a definition of enabling hidden away somewhere, and it's defined to include permitted, controlled and restricted discretionary activity, which might overlap with the providing for.
Yes. Because in my view, I probably see controlled and permitted as those that are enabled, and restricted discretionary probably something that's recognised and provided for.
Okay, well, okay, but you still think that you'd be happy to change your request to providing as opposed to enabling new technologies?
Yes, at paragraph 34, that's my suggestion.
We'll leave that with Ms. Robertson. See what she comes up with. Thank you. Now the
Now,
second.
the only other key issue in my evidence is in relation to the rules for new national grid infrastructure or new lines, overhead lines, electricity lines, and the relationship between rule NUR9 and NUR16. And in my evidence, I reached the conclusion that relying on voltage to have different rules for different lines isn't connected to any particular adverse effect, and that rule NUR16 is unnecessary because there is a rule for lines in NUR9 that should be able to manage the effects of lines irrespective of their voltage. The only distinction really between those two rules when you think about national grid infrastructure is that one takes you at the endpoint to a non-complying activity status, whereas NUR9 is more, I was going to say enabling, perhaps recognising and providing. My view is that voltage doesn't have a direct relationship to adverse effects, and it therefore shouldn't be connected to different rules and activity status. And in the summary statement before you today, it appears that the driver's actually height, like the height of a transmission line or any other structure supporting lines, seems to be the thing that triggers the need for a resource consent for those lines and support structures. Now that is achieved through NUR9 such that my view is NUR16 should be redundant and isn't required in the rules. And that's also driven by my view that effectively this rule is most likely to only affect the national grid and trigger a non-complying activity status, that's NUR16. And by triggering a non-complying activity status, it's my view, it doesn't give effect to the national policy statement for electricity transmission, because that national policy statement requires decision makers to recognise and provide for the development of the national grid.
So, Ms. McLeod, would that mean then practically that you would see the matters of discretion that are currently occurred in R16, you pick up all those 10 matters of discretion and put those into Rule 9?
Yes,
So
that
7 of the 10 are already there.
yes.
Okay. Any further questions of Ms. McLeod or Ms. N in relation to this matter?
No? Is it something we could?
Yeah. I guess this is some useful information for Robertson to consider.
I have to just would like to say that the photos in your evidence as well, with the different going on to that voltage of the distribution lines and transmission lines, that was actually really, I'm a very visual person. It was very useful to actually have that in front of me when I was reading your evidence. So thank you for that.
Thank you.
One of the things that we would need to understand is whether there be any unintended consequences of deleting Rule 16 and relying on Rule 9, and whether there be any consequential changes to Rule 9. Councillor Plummer has already indicated that some of the matters of discretion may need to be carried over. Can you think of anything else?
I proposed the solution in my evidence.
Page
19, paragraph 65.
Yeah.
Yeah.
Okay.
In my view, if those amendments were made, there would be no unintended consequences.
And you're not seeking to change any height from R9 and AU?
No, my view is that it's very likely, well, almost entirely likely that any new national grid line would exceed the height standards. So it would trigger the need for a resource consent under NU R9. It's just that there's no need to distinguish voltage because there are no adverse effects. There will be a need for a resource consent, but the pathway ought not be non-compliant because it's inconsistent with the recognise and provide direction of the NPSCT.
Yes. Can you just cite me the provision in there, in the NPSCT that you're relying on there?
Policy 2.
Thank you. Hey, that's all from me. That's from everyone else. I'd ask Miss Robertson if she was here for any clarifications, but she's not. But I'm sure Miss Adams has got everything recorded. Thank you both for your time and the efficiency in which you've presented.
Thank you very much.
Thank you.
Right, we'll just take the last submitter now before the absentee adjournment. And welcome, Miss Rosser. Welcome back, Miss Rosser.
Thank you. Thank you
I
for
think
having
this is-
me.
That's fine. I think this is probably about the fourth, fifth time I've had you online over the course of the hearing, so you're becoming a regular face.
Oh, thank you.
Now,
Yeah.
we're in your hands.
Thanks. I'm just for this particular hearing, I'm just providing evidence in relation to the matter, just one matter. It's
The definition.
the definition of infrastructure, correct?
Yeah.
So, in terms of that, I'll just give a brief overview of why EnviroNZ have asked for that amendment. The recommendation is that the definition stays the same by Ms. Treadway. She's concerned that amending the definition may have unintended consequences on the rest of the plan. But I do believe that the plan can accommodate the amendment. The amended text is basically that you add waste management facilities, district or regional resource recovery or waste disposal facilities. So that is obviously from the now repealed Natural and Built Environments Act, but it would only apply to specific waste management sites, such as waste transfer sites and landfill sites in the district. And those activities would obviously need to be defined as the main activity on the site. So I note that the Legal Counsel has stated that the Natural and Built Environments Act is not a relevant consideration at this point. But I do believe that that obviously was a direction where future legislation will go. And I believe that the life of this plan is likely to be such that it can consider it now. And I would obviously point out that the infrastructure strategy and waste strategy, along with the emissions reductions plan, that the panel may have regard to all of these in determining the provisions of the plan. And in particular, the waste strategy specifically notes that waste management facilities and services have not always been included in lists of essential infrastructure. So in my view, waste is a bit of a forgotten infrastructure. And although I do believe we do need to be careful about which waste sites we're referring to, I do believe that the infrastructure definition, if it's defined as such, with just the ones of district or regional significance, as it were, can accommodate that amendment. So the reasons, obviously, for doing that as well are so to allow for future waste management sites to be established, and that would obviously be in line with the Wellington Region Waste Minimisation Plan. That plan obviously looks at the fact that things need to be done in the Wairarapa district in relation to food waste processing and construction and demolition waste. I obviously note that the government's relaxed the requirements on those, but I note that there are quite a lot of districts that are still planning to go ahead with those, and those often require new sites to be to enable that diversion to occur. And without being defined as infrastructure, and unless the council is offering that particular service or coming through with that a site for that to happen on, I think plan makes it quite difficult. There are difficult consenting pathways for most waste resource recovery sites, depending on how they're designed, obviously. But I do believe that having waste defined as infrastructure would allow acknowledgement by the plan users that specific regional and district resource recovery and disposal sites are actually infrastructure. Like I said, I do think waste is a bit of the forgotten infrastructure, and it's not often thought about, and or it's at the last resort. It comes after, and it should be at the same time as or before in relation to development. That recognition that these sites need to have the capacity to service new development, particularly obviously large scale plan changes enabling large areas of development, as they are often constrained by their existing regional discharge consents, and they need some forward planning to enable that expansion, to handle that new activity. And recognition that these sites are often subject to reverse sensitivity. I mean, obviously that's I think well known, particularly in relation to landfills. The spice of landfill is I guess a relevant concern in the Wellington region, where residential has crept closer and closer to that site, and it results in a lot of complaints, and the provision of obviously more enabling consent pathways, or just a provision of a consent pathway. So in terms of unintended consequences, I have broadly reviewed the plan and note that the references to infrastructure are usually prefaced with the type of infrastructure. So it's particularly all the rules. I don't think there's any rules applying to the general infrastructure term. It would all be transport infrastructure or reticulated infrastructure, or it might be, under the network utilities chapter. It's obviously quite specific in terms of renewable energy and electricity. And I think by doing that, you can have a planner determine, they can manage the impacts of a proposal, but you can obviously then have regard to the policies and objectives that are generally where the general term of infrastructure comes in. So I think if you've got any questions, that's really highlights the main points.
Thank you, Ms. Rosser. I'll just check with the panel. All right, any questions of Ms. Rosser?
Thank you. Yeah, I've got
Yes.
a couple. Thanks, Ms. Rosser. It's Alistair Plymouth here. I'm sort of not quite sure what you're asking for, because when I read the energy chapter here, it talks about biomass. And then when I read through the rules, there's nothing in the rules that are excluding any development of biomass at all. In fact, whilst it might not be a permitted activity, there are ways and means by which such a energy generation system can come online. So I'm not quite sure what you're trying to ask for when biomass is already in there.
I guess biomass is a very small subset of infrastructure. I guess most waste sites I'd be looking at fall as landfills or waste transfer sites. Obviously, yes, biomass can include composting, or it could be anaerobic digestion. It's more in terms of, because they're not considered infrastructure, they don't have the advantage of the policies and objectives that refer to reverse sensitivity to infrastructure. So once you set those up, they generally do serve a large region, and if you obviously allow, you know, any sort of encroachment around them, you have the ability through those objectives and policies to actually have a think about those issues. Whereas if they're not considered infrastructure, there's no ability to do so.
We've covered quite a lot in other hearings about waste management and the use as well. So I'm struggling with how you would put it into this environment, what we're trying to, these chapters that we're looking at the moment. I'm not quite
Well, this
sure.
was the chapter it was assigned to as the definition. I don't believe it's particularly relevant to the network utilities or energy chapter myself.
That's what I'm struggling. Sorry.
Yes, no, I agree with you there. It perhaps should have been in a different chapter, but probably just the general definitions at the beginning of the set of hearings. But it wasn't actually brought up then, so
I'll just check, are there any further? Mr. Rosser, I think I'm certainly understand what you're saying. Including the term in the definition of infrastructure would give some policy and objective support to the establishment and the protection of existing facilities, presumably.
correct.
When consenting was considered, you're not seeing any raw advantage of including them at all, are you?
No, I've looked through most of the plan and the changes proposed on this sort of chapters, I believe, that are relevant through the hearings, and I can't see anything that would provide for an unintended consequence at this point.
Yes, no, I understand that. That's all from us, I think. Thank you for your time.
Thank you.
Okay. Right, we're going to adjourn in a moment. We've caught up a little bit of time. We were supposed to adjourn at 3 o'clock. And sorry, yes, we're supposed to come back at 3:20, sorry. So we're going to adjourn for 10 minutes, come back at 3:40, so running about 20 minutes late. Just want to take a checklist as to who's in the room. Frank Van Stencil. Welcome, Frank. Josie Rinks.
Yeah.
Right.
Yosha.
Sorry. You, Elizabeth, I know Elizabeth's here. And Mr. Isaac for the South Wairarapa Whenua Advisory Group. Thank you. And we've had an apology from Galen O'Connor, I believe. Yes. That's great. So we've got 4 speakers, each been allocated 15 minutes. So, and then Greater Wellington after that. So we'll come back at 3:40, and then we'll hear from your 4 submitters, and then we'll hear from Greater Wellington at 4:40. Thank you, everyone. You're welcome to change the batting order, but otherwise it'll be Frank, you'll be up first, followed by Yosha, Elizabeth, and